Thank you. I reconvene the meeting of the Legislative Committee on Judicial Rules, October 21st, 2021. And I do have an initial question right off the bat, perhaps for Legislative Counsel Eric. We have 4 people here in person and 3 people virtually. Does that mean that we do not have a quorum? I know that people virtually are not able to vote, but do they count for a quorum?
Interesting question. Mike, have you heard that question raised recently in your other committees that you've staffed or?
So with joint committees,
Yeah,
the committee has to have an in-person quorum.
that's what I thought.
Okay, so we won't be taking votes today unless somebody magically shows up, which I don't think anybody will, because I know that Senator Hinsdale is unavailable. So we'll just go ahead and hopefully we won't come to something that we have to vote on. All right, so moving ahead, I guess that means that we don't approve the minutes until next time.
Correct.
Exactly.
Okay, so we'll move ahead to committee discussion. Yes.
Mr. Chair, may we ask questions on the minutes or are we just going to, we're not even opening them up for discussion?
Well, I would think that we'd want to, what do you think, Eric? Would you like to have the questions on the minutes in advance? So
That way,
yeah, go ahead. Yeah, go ahead.
Oh, there were no questions on the superb quality of the minutes.
Yeah, are there any
It's
questions?
only a substantive, I mean, it's a substantive concern about the e-filing. And between now and the next time we meet, lots could be being done. And I just, it's an issue that continues to concern me. And I know concern legal practitioners around the state, and there are all sorts of concerns. I mean, the rollout is not as seamless as I think judiciary would like us to believe. And there are a lot of ongoing concerns about multiple copies having to be filed in one, pro se's. I mean, there are continuing issues, and would love to hear, and Emily's the only person here from the judiciary, but I would like to have an understanding that the judiciary is actually reaching out to the practitioners in court, the essays, the defense, the pro se's, the people that are using this system and trying to improve it, because I keep hearing lots of ideas about how to improve it, but I'm not sure they're being heard.
So would you like to add at the end of the agenda, if there is somebody from the court that can address that today?
I would hope so, because the next time we meet will be months or a month or whatever from now. And
Right.
This is an ongoing issue that can be being improved as we, before we next meet.
Okay, so yeah, if we could have Emily, if there's somebody you can reach out to who might be able to join even virtually, or somebody will be here to perhaps address that question at the end of the agenda, if that's possible.
I spoke with Eric before the meeting, Emily Wetherell, for the record, and Pat is not available. She's not available for today. I don't think anyone else has, we didn't discuss anything related to that on the agenda.
Right.
So there is a portion where I'm testifying related to e-filing implementation at the Supreme Court, and there are questions that I can answer.
Mr. Chair, I'd just like to jump in. I did receive an email this morning from Terry Corsones. The Bar Association was having a meeting at noon time with court staff to talk about Odyssey and all of its ups and downs. The hope being that would be an ongoing conversation. I don't think they're going to give us any information today, but just wanted the room to know that in fact there are meetings taking place, and at some point we probably do want to have a full-fledged discussion about that on the agenda.
Right, okay. So should we still see if there's some particular questions that you want to have Emily answer at the end of the?
I just have a direct request that I'm thrilled to know that the Bar Association's addressing this. I would just love to ask the judiciary to engage more fully with your state's attorneys, your defense counsel, about ways to improve, and the police departments, because the police, the state police, pro se's are not filing and don't know how to do it, and are having some challenges with it. And there's still no option for people to file multiple copies with things. So I would reach out to your users more fully and see what can be done to improve it, because it's ongoing and it should be seamless by now.
Right, okay. So a message has been sent, certainly. Thank you very much. And we'll proceed. So I do have on the agenda, hopefully a brief discussion on administrative orders generally, but more so administrative order 49. And I'd just like to set up the discussion, the couple of questions that I am hoping to get some input on from the rest of the committee today. So among other things, administrative order number 49 authorizes the chief superior judge to transfer a criminal proceeding to another unit for purposes of jury trial. It authorizes the chief superior judge to change venue in any matter during the judicial emergency. So whether this authorization is lawful or was lawfully enacted has been raised in litigation. Specifically, a criminal trial that would, in normal circumstances, be held in Windsor County was scheduled for trial in Windham County. In an unopposed motion, defendant objects to this change of venue and is arguing in part that administrative order 49 does not provide sufficient authority for the venue change. Defendant argues that administrative order 49 did not go through the review process before the Committee on Judicial Rules and therefore does not authorize the venue transfer. So this litigation is not the only sign that litigants are concerned about the court's authority to change venue pursuant to AO 49. In any event, I believe the concern raises some questions that this committee may wish to consider. For instance, should the committee start considering the court's administrative orders more formally than it has been? Also, should the committee formally review Administrative Order 49, particularly as it regards venue? Now, I'm not suggesting that we get into the substance of these questions today. Rather, I really have two questions I want to get input from the rest of the committee. And that is, should we schedule a hearing to take up these questions? And I think just related, should we wait until the court has, in the first instance, addressed the issues before we decide to review Administrative Order 49, because it is in front of the court in at least one motion, and there could be others in the state. So in any event, I open that up. If anybody wants to weigh in, I have some views as well, but let's hear if anybody else has any views on that. Okay. Senator Manning.
So this is an issue that is quite prevalent in the court at the moment in time, especially my neck of the woods in the Northeast Kingdom. We have had as a bar several conversations about this process, and when it comes to the criminal arena, both the prosecution and the defense attorneys are in agreement that there are major issues with venue changes, and we are universally opposed. I haven't heard anybody that has been in favor of this subject. I recognize that the court houses are going through the same discussion that this state house is going through. How do you reopen, get people involved? What things are you looking at to determine what is the way to do it, what's not the way to do it? It became apparent to me in a court proceeding not too recently in St. Johnsbury, where in preparation for a court proceeding, I believe Judge Tomasi, it was you and I who had this conversation, that one of the things that was being looked at during a jury trial would be the CO2 levels in the room. As chair of institutions, I have been very involved for several months now in what is going on to monitor things at the State House in order to reopen the State House. When I heard that CO2 monitors might be a triggering mechanism for causing a pause in the trial, it was the first time in my conversations that I'd ever heard such a thing. And I am aware that the engineers who are advising the court system are different than the ones who are advising the State House. And I don't see why we would have a difference of what we're monitoring in both buildings. So that became a concern of mine. And as chair of institutions, I feel I have really a major part in trying to make sure this conversation is fleshed out better than it has been. There has been a motion filed in Orleans Superior Court that a trial now pending there not be moved to Lamoille County. And the attorney for that has objected, has had some conversations with various players. And as a result, I felt that it was very important that this committee take a look at what's going on. We are an independent body from the judiciary. Yet we are the body that actually funds the judiciary and provides the court facilities for the judiciary. So I think it is important that this committee at least hold a hearing to determine what is going on and provide the public with an opportunity to weigh in and present evidence on what is or is not necessary. I would not want to wait for the court proceeding to be concluded. We have no idea what that conclusion will be and whether or not it will match what legislative intent is. I will also say that on April 30th of this year, this committee received a report from Emily Weatherall about 5 amendments that were being presented. I went back and I watched that video last night of our proceeding, and the 5th amendment that was being talked about was AO 49 and its impact on the courthouse. There were roughly 20 seconds that presentation was made, and I'm not trying to disparage anybody, I'm just trying to point out for the record that this committee has had 20 seconds worth of testimony about this amendment being presented. We took no substantive testimony from anyone after that. The conversation was cut off when Senator Sears asked about a letter he had received from a constituent regarding juvenile proceedings. Later on in the conversation, about 20 minutes or so in, Justice Eaton came before us to talk about civil jury trials. And that conversation morphed into 6-person jury trials and what was going on with advancing the civil jury trial schedule. So we really haven't, as a committee, had an opportunity to listen to testimony about why buildings are or not being used. I think it is incumbent upon us to have that conversation. I do think that the administrative order, although it is not a rule per se, is perfectly reviewable according to the statutes giving this committee authority to do things. I'll also point out that this morning in LCAR, we were having a similar conversation on the housing situation and the administration's decision to pause its terminating funds for those who are homeless residing in motel spaces. There is no rule per se that normally would have come through the Administrative Procedures Act, but there is this activity going on and we had to get a grasp of it. And so the conversation is very similar. I believe that the legislature has a right and a responsibility to know what's going on in the judicial branch, and that we are technically, as the people's representatives, the responsible place for that conversation to happen. So I would ask we actually set up a meeting to have this conversation and to invite all players to the question in for that conversation so we can get a full picture.
So I have a question for you, a follow-up question. So would this then be in the context of reviewing the administrative order 49? And the reason I ask that is that I don't think it's within our jurisdiction just to have a broad oversight of the courts and whether they're doing the right thing as far as getting courthouses open or not. I don't think that's subject to, it's at least not directly subject to AO 49, but I don't think absent some sort of rule to be reviewing, I don't see us being able to get into a broad discussion like that.
I guess I would respond by saying that the title of the discussion may be AO 49, but the specific request that I have is, do we examine or not examine how the court system is opening up to proceed with trials? I would counter that we do in fact have that ability under our authoritative statute. I would also suggest that the people who are affected by the decision the court has made have no place else to go to have that conversation. And that's why we are elected representatives of the people. And I think we have a responsibility and a right, frankly, to have that conversation.
So, Senator Clarkson?
I would support Senator Benning's support of having a hearing on this very subject. I think there's a concern about the infringement of public access and access to justice. And I think if people are going back to the movies, they need to be able to go back to court, and we need to figure out a way to do it. We have, from a budgetary point of view, we have allocated the funds to do this. ARPA has allocated funds to, I mean, I have a lot of concerns about our access to justice. And so I would support this hearing and having exactly that hearing. I think we are, and I think that, I don't know where there are other concerns with that too. So, but I would support doing a hearing on this, and we have members here.
I see Senator Sears has his hand up, but just in one moment, Senator Sears, because I actually have a question that you could perhaps provide insight in as well. And that's whether this, excuse the use of the term venue, but whether this is the appropriate venue to consider this, or would this be for joint justice oversight? Wait, we're getting, just a sec. I don't know what. I don't know what. All of a
I was
sudden,
unable to hear the question.
speaker in here, which is throwing me off. I think it was coming. No?
It's when Terry walked in the room.
Just 1 second, Senator Sears. Technical issue. I don't know where that.
Don't we have an
Can we unplug the speaker?
Okay. Is that? Everyone's muted. I have no idea where they're. Now? Is anyone on there?
What? Is somebody on there?
It's not doing.
Let's see if it's that. I don't.
It appears to be one of these, Michael. If you mute these right here.
All big speaks anyway.
Can you turn the speaker off?
Yeah,
They wouldn't be able to. We can turn the speaker off. I can turn it off here from the speakers. And representatives should be able to hear us, right, Senator Sears? You can hear us right now, but we won't be able to hear you because your audio comes through those speakers. So I'm gonna alert our IT team to this now. This has not happened here, and I've done a lot of meetings at this room like this. So
I'll just finish my question and then we can turn this on for Senator Sears. Just wondering if this is more appropriate, the broader issue, if we're not looking specifically at a rule or administrative, but we're looking generally at how the courts are or are not opening, whether that's oversight or if that's an issue that either Senate or House or both judiciary committees actually convene to take such testimony and consider that issue. I'm just wondering where, if it's a broader issue and not the administrative order that we're reviewing, where that should occur. And if you could turn on, or Sears, perhaps he can weigh in on that and just generally what he had his hand up for as well.
So I'm gonna turn him on and mute.
Can you hear me now? If you can't hear me, I'll just write it in chat.
Senator, just 1 second. We're working on it.
Senator Sears, can you hear us?
I can hear you perfectly.
We cannot hear you.
Dick, if you can hear us, give us a thumbs up. Yeah, so he can hear us.
We can't hear him unless that speaker is on back there.
And Mike's turning it on.
Representative Burdick, can you say something just so we can get an audio test from you?
Hello, everybody.
It's not working either.
We can't hear.
I can hear you.
How about now? Does that work?
Can you hear me now?
Now. I,
Mike, you want me to go look for Shadi?
Reboot the system and get you back online.
I'm gonna keep the Zoom open. I'm gonna take us off YouTube and I'm gonna reboot the room. And then relaunch. Sounds good. We need to do.